What are intellectual property rights? Let's start with the very basics. What does intellectual property even mean? So let's say you design and manufacture chairs, and your name is worldwide known for the great quality chairs you design and make. Now, if someone breaks into your storage and steals your chairs, that's property theft. But if someone copies the design of your chairs and starts manufacturing the chairs themselves, that's intellectual property theft. The same goes for a situation where someone starts marketing their chairs with your name on them, even if they would use a different design for the chairs. Tangible property, so the chairs in this example, can be protected physically, like keeping your chairs in a locked storage with camera surveillance and an alarm system, for example. But intangible property is typically easily accessible by anyone, anywhere in the world. So this is why we have intellectual property legislation. IP legislation is our society's way of setting up rules for the use of intellectual property. What do we consider to constitute as intellectual property? What do IP owners have to do to get their IP rights? What do those rights include? And what can the right owners do if someone steals their intellectual property? Different societies regulate things differently, and it's good to realize that intellectual property legislation varies country by country. So please check with a local IP attorney or lawyer for your country-specific legislation. This also means that you need to apply by the local IP legislation in each country or area where you seek protection. The rules we discuss in this mini-lecture are based on EU legislation. Intellectual property legislation has always been linked to how easy it is to copy creative and innovative work. The early forms of copyright legislation, for example, were created to grant authors exclusive right for a limited period after the first print press was invented. Before that, such exclusive rights were not granted by legislation, but at the same time, copying a book was done by hand, and so the threshold for copying was naturally quite high. Also, design, creativity, and innovation were inseparable to craftsmanship. But the Industrial Revolution changed this significantly. Copying innovative and creative works and products became easy and cheap. And this is the time that a lot of the early forms of modern IP legislation took form. So the purpose of intellectual property legislation is to protect and incentivize innovation and creativity. Without IP legislation, product and service markets would only be about commercialization power. Sometimes people mistake utilizing intellectual property legislation to mean very restrictive, closed, and controlled method of utilizing intellectual property rights. This is a common way to use intellectual property rights. Only use the innovation yourself and prohibiting others to do so. But it is only one strategy. You can utilize intellectual property rights in a very open and communal way, but still allowing you to prohibit use of the innovation that doesn't match with your values. For example, only allowing ethical and sustainable manufacturing and having the opportunity to prohibit counterfeit products produced with possibly even poisonous materials in dangerous working conditions. So, as a society, we have IP legislation to protect creativity and innovation and to allow creators themselves to make a living from their work. And from the company's point of view, we want to incentivize investments made into innovative and creative works. But as with most legislation and policies, it's a balancing act. So on one hand, we have protection of creativity and innovation, and on the other hand, we have protection of free competition. This is why IP legislation typically grants exclusive rights only for a limited period, and many times exclusive right only applies to commercial and professional use. And some things are categorically left outside of the scope of IP protection, such as ideas, concepts, and recipes, for example.